Law of Trusts, Part 5. Already we have covered 4 topics. This is a 5th topic that we are going to cover today. This topic allocated for the unlawful purpose of the trust. We have seen already the purpose of the trust. The purpose of the trust must be certain in terms of Section 6 of the Trusts Ordinance. Now here we are going to see the lawful purpose of the trust. Sections 4 and 98 of the Trust Ordinance require lawful purpose of the trust created under Chapter 2 and Chapter 9 of the Trust Ordinance respectively. Section 4 falls under express trust. At the same time, Section 98 of the Trust Ordinance falls under constructive trust. Even if these sections 4 and 98 of the Trust Ordinance had been omitted from the Trust Ordinance, the general law would have prevented the operation of trust for unlawful purpose or illegal purpose. Now we will see the Section 4 of the Trust Ordinance. A trust may be created for any lawful purpose. It is in the direct sense clearly said that any trust may be created for lawful purpose. As we have seen, there are trusts for charity or charitable trusts. There may be trust, the same heads for private purpose also. Maybe a private trust or the charitable trust. Trust may be created for any lawful purpose. The purpose of the trust is unlawful unless the purpose of the trust is lawful unless it is forbidden by law or prohibited by law. Second, it is of such nature that if permitted, it would defeat the provisions of any law. Third one is very clear. It is fraudulent. Fourth one, it involves or implies injuries to the person or the property of another. Finally, the court regards it as immoral or opposed to the public policy. These are the circumstances expressly said. The trust cannot be created. Then generally, the trust can be created for any lawful purpose unless the purpose is forbidden by law, or if the purpose it would lead to the violation of any certain laws, or if it is a fraudulent, or it may cause injuries to any person or property of others. Finally, courts regards it as immoral or opposed to the public policy. Section 4.2. Earlier we have seen Section 1, subsection 1 of Section 4. Now we are seeing subsection 2 of Section 4. A trust which purpose is unlawful shall be void. Then very clearly said that. The first subsection 1 clearly says the trust should be created only for lawful purpose. But here, again emphasizes same principles, a trust which purpose is unlawful should be void. and where the trust is created for two purposes, one of which is unlawful and non-separable from other purpose, the whole of such trust shall be void. Then there may be more than one purpose. In that case, if it is for so many purposes or more than one, then we must see whether the purposes could be separated. If it is possible, the purposes, if it is the purpose is legal or lawful, then the trust may be allowed to create or allowed to proceed. But if the purpose is unlawful, that should be void. And also we must see whether it is a separable or not. If it is non-separable, then there is no second word. The whole trust shall be void. If the two types can be separated, the trust as whole will fail, but shall stand for those objects which are lawful. The simple thing is, when you summarize section 4 of the Trusts Ordinance, the first part is any trust can be created for lawful purpose. The lawful purpose should not include the following like forbidden by law or other things that we have seen, or it's a fraudulent, or if the court decide that it is against a public policy, then those are the circumstances where the trust or the purpose is unlawful. Then the second step that we have taken, if the purpose of the trust is unlawful, then what is the next? Then the whole trust is void. If there are two purposes, and also the second condition, the first condition, there should be more than one purposes. Then if take the two purposes, then the second condition is that should be separable. If it is separable and more than one purposes, then whatever possible, you would separate the legal purpose or the legal or lawful purpose and give effect to that. Then we can see some illustration given to section 4. A bequeaths property to B in trust to employ it in carrying out a smuggling business, and out of the benefits thereof to support A's children. The trust is void because smuggling business is prohibited by law. It is an offense in law. Then it cannot be done. The second purpose is to give the profit to somebody, that's A's children. Then in that case, you can separate here smuggling business separately and give some profit to the children. In this case, it cannot be separable. That's why the whole thing void. Trust is void. Then we will see the illustration B to the section 4. In terms of the illustration B, A, while in insolvent circumstances, transfers the property to B in trust for A during his life, after his death to B. Then the A transfers his property to B to hold the property for the benefit of A. Upon the death of A, B can take the property because it is for his benefit and this is already property transferred. A is declared and insolvent. The trust for A is invalid as against his creditors. Because this is the idea to cheat the creditors, that's why it is prohibited by law. Then it is void. Now we will see the law of contract and law of trusts. Compare the unlawful trust and illegal contract. Unlawful trust and illegal contract are governed by almost similar principles. It is cited in the Veeramandri's book, Law of Contract. Veeramandri divides the illegal contract into three categories. Contracts illegal by statute, contracts contrary to the common law, that's the Roman Dutch law, and contract contrary to the public policy. These are the circumstances where the contract becomes illegal. The same principle may be extended to the unlawful trust. When you see this section 4, as we have seen earlier, when you apply these things there, you can see the connections between law of contract and law of trust. When we see this one, contracts illegal by statute, that's known as here 41A. The purpose of the trust is unlawful, or purpose of the trust is lawful unless it is forbidden by law. Here in the case of contract, illegal contract, Veeramandri divides into three categories. The first category says contracts illegal by statute. That's a thing. Here in law of trust, section 41A provides that the purpose of a trust is lawful unless it is forbidden by law. Second thing is, in the case of contract, as Veeramandri divides those things into categories, second one is contracts contrary to the common law. Contract contrary to the common law. This may be like in the case of contract under section 4, the purpose of the trust is lawful unless it is such a nature that if permitted, it would defeat the provisions of any law. Finally, contract contrary to the public policy. Here in the law of trust, section 4, 1E says, the purpose of a trust is lawful unless it is the court regards it as immoral or opposed to the public policy. Whatever circumstances given by Veeramandri in the law of contract, similar to the section 4 of the Trust Ordinance. Now, when you see the unlawful purpose, as we have seen in section 4, in terms of section 4, the unlawful purpose is void, and the trust also void. The purpose is void, and finally, unlawful trust is void because it is in violation of section 4. Now, once the property is transferred, say suppose there's an immovable property, then the trust is created in relation to the immovable property, whether it is a lawful purpose or unlawful purpose. First place, the property should be transferred, and the deed of trust must be executed. Then everything done. Then only we identify that the purpose is unlawful. Because of that, the trust is void. Then the property transferred already to another person, where a trust has been created or arisen for unlawful purpose. Now there are two words we have used here. The trust has been created or trust has been arisen. When you say trust has been created, it should be under chapter 2 of the Trusts Ordinance. Trust has been arisen in the sense it is under chapter 9 of the Trust Ordinance. Then where the trust has been created or arisen for unlawful purpose, plus the property was transferred to another person, then when you see the express trust, as we have seen in terms of section 5 of the Trust Ordinance, 5.1 and 5.2, in the case of immovable property, the property should be transferred. When you see the section 5 of the Trust Ordinance, subject to the provisions of section 107, no trust in relation to the immovable property is valid unless declared by last will of the author of the trust or of the trustees, or by a non-testamentary instrument in writing signed by author of the trust or the trustee and notarily executed. Then that's very important. Then the first of all, the trust must be created. Then the deed of trust must be signed by the author of the trust. Second thing, when you see in terms of section 6, the hanging provision says, unless the trust is declared by will or author of the trust himself to be a trustee, transfer the trust property to the trustee. Then the trust is created under the chapter 2 of the Trust Ordinance, that's the express trust. The property must be transferred to the transferee, that's the trustee. And the author of the trust must transfer the property to the trustee. Likewise, here also, even though it is for unlawful purpose, the first thing is under chapter 2, the deed of trust must be executed and the property must be transferred to another person. That is here trustee. But when you see here, trust is created or arisen for the unlawful purpose and property also transferred to another person. Now we say that in terms of section 4, trust is void. Then what happened to the property? That's why here, what is the destination of the trust property which was transferred to another person? destination of the trust property in the case of unlawful trust under Chapter 2 of the Trust Ordinance. Now we are talking about the unlawful trust under express trust and also in terms of Section 4 of the Trust Ordinance. Where a testator bequests certain property upon trust and the purpose of the trust appears on the face of the will to be unlawful, or during the testator's lifetime, the legatee agrees with him to apply the property for unlawful purpose, then the legatee must hold the property for the benefit of testator's legal representative. Now when you see under Section 5, once a trust is created, the property should be transferred to trustee. But after, because of the purpose of the trust is unlawful, the trust is void in terms of Section 4. Even though trust is void, the property, now the property is in the hand of third party. That's why when you apply the Section 87 subsection 1, it some extent that the trust is arising by operation of law. That's why here, where a testator bequests a property on trust, therefore in terms of Section 4, if the purpose is unlawful, it is void. However, the property had been transferred to another person. That's why in terms of Section 87, trust is arising in that circumstances. Now here in terms of Section 84, the testator transferred the property on trust. Because it is a last will, once a person dies, it comes to the effect. Therefore, if once it is in operation, if the purpose is void, purpose is unlawful, then it is void. Then the person who has received the money or the property must hold the property not to the testator because he has already died. Then he must hold the property for the benefit of testator's legal representative. Now, in terms of Roman Dutch law, there's a rule says no one should be enriched in the expense of another. That is the basic rule in Roman Dutch law. At the same time, when you see Section 87, by operation of Section 87 of the Trust Ordinance, trust is arising to prohibit another person to be enriched by the transaction. It may be extended to Section 85 of the Trust Ordinance also. When you see the Trust Ordinance, Section 85 of the Trust Ordinance, where a trust is incapable of being executed, or where a trust is completely executed without exhausting the trust property, there are two circumstances. First one, the trust is incapable of being executed. Maybe because of the unlawful purpose. Maybe, may not be. But the trust is incapable of being executed, or the trust is completely executed without exhausting the property, then the trustee, in the absence of directions to the contrary, must hold the trust property or so much thereof as is unexhausted for the benefit of author of the trust or his legal representative. But it doesn't say that the trust is incapable of being executed because of the unlawful purpose. If we apply section 85 for this purpose, then more or less every section in the constructive trust may be extended to the purpose of unlawful trust. But here one may argue that under section 85 of the trust may arise because section 85 provides where a trust is incapable of being executed, then what happening there, the resulting trust is arising. It does not speak anything about unlawful purpose. Then if section 85 is held not to apply, in terms of section 87(1) that we have seen, the trustee of the unlawful trust would hold the property on resulting trust for the settlor in the exceptional circumstances allowed by the maxim of pari delicto or under section 86. When you see section 86 of the Trust Ordinance, transfer for illegal purpose. Where owner of the trust transfers it to another for illegal purpose, this is not connected with express trust, because the difference between 86 and 87 in terms of section 87, where a testator bequeaths certain property upon the trust and the purpose of trust appears on the face of the will to be unlawful, then there is a trust. Now here under section 86, where an owner of the property transfers it to the another person for illegal purpose. Now this is a place where the trust is arising. But under section 87, there must be a trust first of all. That may be under section 5 of the Trust Ordinance, that is express trust. But here under section 86, transfer for the illegal purpose. The owner of the property transfers that property for a illegal purpose. And such purpose cannot be carried out in execution, or the transferor is not as guilty as transferee, or the effect of permitting transferee to retain the property must be to defeat the provisions of any law. In those circumstances, transferee must hold the property for the benefit of transferor. Then when you summarize section 86 once again, where owner of the trust transfers the property to another person, and the purpose of the trust or the purpose of that transfer is not carried out into execution, may be unlawful, or otherwise there is second circumstance given here. The transferor is not guilty as transferee. Then there is a comparison between transferor and transferee. Then the transferor is not equal to or the not guilty as transferee, then transferee is more guilty than the transferor. Or the effect of permitting the transferee to hold the property or retain the property must be to defeat the provisions of any law. Then these are the circumstances. Then what happened? The transferee must hold the property for the benefit of transferor. This is a circumstance where the trust is arising. Now we will see destination of the property in the case of unlawful trust under chapter 9 of the Trust Ordinance. Up to now we have seen the destination of the trust property in the case of unlawful trust under chapter 2. Under chapter 2 we have seen there's a trust may be created under in terms of section 5 in line with section 6. In addition to that, the property should be transferred to the trustee. But the purpose is unlawful. Then the trust is void, but the property already transferred. Then we apply section 87 and the transferee must hold the property for the benefit of transferor. It is in terms of Roman Dutch law, it is correct. In terms of Roman Dutch law, there is a rule in Roman Dutch law says no one should be enriched at the expense of another. Now here we are going to start destination of the trust property. In the case of unlawful trust under chapter 9 of the Trusts Ordinance. Section 4 in relation to the chapter 2. As we have seen up to now, as I told you earlier also, section 4 falls under chapter 2. Therefore, in relation to any express trust which is created by another author of the trust should come under chapter 2. But here what we are going to see now, section 8, chapter 9, that's the constructive trust. Sections 82 to 98 of the Trust Ordinance deal with the constructive trust. Section 98 of the Trust Ordinance comes under chapter 9 of the Trust Ordinance, that is constructive trust. When you see the constructive section 98 of the Trust Ordinance here, nothing contained in this chapter shall impair the rights of the transferee in good faith for valuable consideration. That's one part. Then this chapter, the provisions of constructive trust. Provisions of the sections in relation to the constructive trust. Or the provisions under chapter 9 shall not impair the rights of the transferee who has purchased the property in good faith for valuable consideration. That's one thing. Second thing, nothing in this chapter, that's the constructive chapter, shall not create, simply say, the provisions of the constructive chapter shall not create any obligation in evasion of any law for the time being in force. In evasion of any law. Evasion, when you talk about evasion, you must differentiate another word, avoidance. Evasion and avoidance, the two separate words and very powerful word in the law of tax. Avoidance of tax, not an offense, but evasion of tax, an offense. Evasion in the sense as the L.J.M. Hure cited in his book, Reception in Ceylon of English Trust. In page number 93, the word evasion in section 98 implies an intentional attempt to circumvent the existing law. Intentionally circumvent certain provisions of the existing law and does not touch a case which merely happens to conflict with a strict law. Then when you say evasion of law, there should be an intentional action to circumvent or violate the existing law. Then merely there is a violation, it should not be evasion of any law. There may be provisions of law. It may be violated, but it is not evasion of such law. It depends on the circumstances. Then we must see what is the lawful purpose or what constitutes the lawful purpose or unlawful purpose. When you define the word evasion in section 98, always we must see there's an intentional attempt to circumvent the law. Then what is that? First, when you say that, what constitutes the illegal purpose? How to identify this illegal purpose? Maybe illegal, maybe lawful. Unlawful, lawful. How to identify? How to identify first of all? That's why here we have given about 6 circumstances as given in the L.J.M. Hure's book. First one, A transfers or the purchases in the name of B. A transfer the property to B or A purchase the property in the name of B to enable B to institute legal proceeding. Now this is one way in which maybe when you see that it may not be lawful or unlawful, but we must see the circumstances in full. A transfer the property to B to enable B to institute legal proceedings. A transfer the property to B to seek particular employment, because if you have some property only, you can get some employment. Sometimes in certain employment, there may be a requirement to deposit certain money. Then in that case, A transfers his property, maybe movable or immovable property, to B to seek particular specified employment. Or sometimes there may be a qualification or there may be a requirement to be in the election, to contest in the election. Then in that case, say suppose B is going to contest the election, but B has no enough or such property to be a candidate in the election. In that case, A transfers the property to B to make him enabled to contest the election. That's why A transfers the property to B, or A purchase the property in the B's name to stand for election. Finally, A transfers the property to B to act as surety. That's wrong. The given four circumstances as per the book, LJM Hoore's book, that's the receptionist known of the English Trust, he said that in the last circumstances, the last instance, it has the illegal nature of the transaction, but the A's claim. Now the issue is, as once again, the property is transferred once the trust is created in terms of section 5. Trust deed is executed in addition to that property transferred. Now the problem is to get the property back to him. If there's a unlawful purpose, then we must identify the unlawful purpose. To identify the unlawful purpose, these are the circumstances. But when A transfers a property to B, only in the last instance, it is illegal nature. It has some sort of illegal nature of the transaction which prohibit or which bar B's claim. Then we will see the next one. Where A is forbidden to purchase certain property in his name because the government servant cannot purchase without certificate, and provides consideration and purchases in B's name. It is not illegal. It is not illegal in terms of section 98. Now we see what is known as evasion of law. Because if it is evasion of law, then we must discuss separately. If it is not, then it is not illegal. There is a trust. Then we must consider whether it is lawful or unlawful, first of all. But in section 4, it's clearly said. But here, it doesn't. Therefore, in evasion of law, in the sense, we must identify which is in evasion of law. For that purpose, we must identify which constitutes the unlawful. Now here in this one, second one, where A is forbidden to purchase certain property, but he purchased. Why he has been forbidden to purchase a property? Because he is a government servant. At that time, the government servant can purchase a property unless he has a certificate. Then first of all, we must apply the certificate and get the certificate, then only he can purchase a property. Maybe to prevent the bribery and corruption. Then A is forbidden for the purchase of property because he is a government servant. He provides the consideration and purchase of property in B's name. That is not illegal. That's in relation to Pereira versus Gnodana. And third circumstance, a conveyance to the purchase of property in the name of B by A. Then A purchase a property in the name of B. Why he has done like that? To then so that the tax on such property would be reduced. For the purpose of getting some sort of reduction in the tax payment, he has purchased of such property in the name of B. But here it is illegal purpose, unlawful purpose. It is not mere violation, it is a total violation. Therefore, there's a evasion of law. That's why in section 898 that we have seen evasion of law. Nothing contained in this chapter shall impair the rights of the transferee in good faith for valuable consideration or create an obligation in evasion of any law. Create an obligation in evasion of any law for the time being in force. For the time being in force. Then here, when you compare those two circumstances given in section 2 and 3, the two, he really is forbidden to purchase a property as a government servant, but he purchased a property in the name of B. But it is not an evasion of law. But the second thing, the conveyance to a property purchase in the name of B by A, so that the tax on the property would be reduced, it's illegal purpose. Then that means this is something evasion of law, especially tax law. But very recent case that we must see now, in 2011, Saroja Nisangela versus Appellant. Appellant had been in Dubai, and where she had been working for several houses and had stayed at a respondent's house. She had not paid any rent. In lieu of rent, what she has done, she helped to clean the garden of the respondent. The respondent agreed to purchase a house for appellant and did so. He agreed to purchase a property, and he purchased a property in the name of appellant in Sri Lanka. Then what happened? The issue was as to whether a purchase of property by third party for or on behalf of foreigner allegedly in order to evade the payment of 100% tax on sale could create a trust on the basis of section 4.1 and 98 of the Trust Ordinance. Really speaking, we no need to talk about section 4.1 of the Trust Ordinance here, because 98 is there, and also trust arising, not created here. Therefore, one can argue on the basis of section 98 of the Trust Ordinance, not in terms of section 4.1 of the Trust Ordinance. But no harm in arguing on the basis of both sections 4 and 98 of the Trust Ordinance. The basic issue was as to whether the purchase of property by third party for or on behalf of the foreigner. Now the property, Dubai citizen purchased a property in Sri Lanka. Alleged then that the purpose is here, the issue is here at the time of purchase. When you see section 98 of the Trust Ordinance, it provides that nothing contained in this chapter shall imply the rights of the transfer in good faith for valuable consideration. That one part. The second part is nothing contained in this chapter shall create any obligation in evasion of law for the time being in force. For the time being in force. When he purchased a property in Sri Lanka, there is a requirement to pay 100% tax. If a foreigner purchases a property in Sri Lanka, he must pay 100% tax in terms of Finance Act in Sri Lanka. Later on, the Finance Act was amended, and now it is absolutely prohibited. Now the foreigner cannot purchase. There are some exceptions given in that law. The land alienation or restriction on alienation act, I think it must be in 2014 act. Then in this case, when the foreigner purchases a property in Sri Lanka, the Finance Act required to pay 100% tax. Then here the appellant argument was that the foreigner purchased a property to avoid or to evade the payment of 100% tax on sale. Could create a trust on the basis of section 98 of the Trust Ordinance. The section 98 of the Trust Ordinance saving the right of bona fide purchase. That's the first part that we have seen. Nothing in this section or nothing contained in this chapter shall impair the rights of the transferee in good faith for valuable consideration. If the person purchases a property in good faith, that's a bona fide purchaser. Then 98, provisions of 98 saves the rights of the bona fide purchaser. Now we will move to other slide here. The appellant contended that there's a breach of revenue law. Then that means the evasion of law here. Therefore, the respondent cannot seek any relief under Trust Ordinance. The court cited as follows. Dr. L.J.M. Hure, in his work on the subject of trust, has discussed the nature of the lawful trust. According to L.J.M. Hure, if sections 4 and 8 of the Trust Ordinance had been omitted, the general law of the land would have prevented the operation of trust for unlawful purpose. That we have already seen also. Referring to trust for unlawful purpose, Dr. Hure refers to Professor Veeramandari's treatise on law of contract. Professor Veeramandari, referring to breach of revenue regulation, clearly states that mere breach of revenue regulation would not itself render illegal a contract in respect of which they are imposed. That's the very important point here. Referring to trust for unlawful purpose, Dr. Hure refers to Veeramandari's law of contract book and said that Veeramandari, referring to the breach of revenue regulation, clearly states that mere breach of revenue regulations would not render illegal a contract in respect of which they are imposed. Now 100% tax on foreigners' purchase is a tax on the matter. It doesn't say that it is illegal or offense. If you want as a foreigner, if the foreigner wants to purchase a land in Sri Lanka at that time, he can purchase by paying 100% tax. The tax should be recovered in terms of the provisions of the Inland Revenue Act. Professor Veeramandri stated that where the statute merely imposes a penalty on the performance of certain acts without declaring such an act to be illegal or void, the question arises whether such acts are void. In such cases, we must look to the intention of the legislature to see whether the imposition of penalty implies as to make a resulting contract void. Therefore, as per Professor Veeramandri, where a statute imposes a penalty on the performance of certain acts without declaring such acts to be illegal or void, the question arises as to that act void or not. Then in that case, in such cases, we must look to the intention of the legislature to see whether imposition of penalty implies as to make resulting as void. The imposition by legislature of a penalty on any specific act or omission is prima facie equivalent to express prohibition. The imposes of 100% tax on the purchase of any land in Sri Lanka by foreigner it is express prohibition. Is it express prohibition? Actually not. Because imposition by this is not penalty at all. In the present case, the foreigner must pay 100% tax. It doesn't say that there's a penalty. It's regularizing. It is regularizing the purchase of property by foreigner. The imposition by legislature penalty doesn't apply here. But however it is, imposition by legislature of penalty on any specific act or omission is prima facie, that is prohibited. That's all. Such provision, however, only prima facie evidence, and it is not enough by itself to make a contract to do that act illegal or void. If you do certain or if you enter into the contract regarding certain matters, you must pay such amount of penalty. It doesn't say anything else. In that case, such provision is just a prima facie evidence, and it is not enough by itself to make a contract to do that act illegal or void. Court said that an act could not be treated as invalid simply due to the illegality. Then all the illegality matters, or all illegal matters do not become void. All the void matters are illegal. As per this judgment, we come to the conclusion that the court said that act could not be treated as invalid simply due to illegality. Then maybe the lawful or unlawful, but we must see the circumstances. We must see whether there is a evasion of law. If the evasion of law, that's different thing. For the purpose of identifying whether it is evasion of law, then we must see where there is an offense and declare. Then there are matters here. First of all, there is a prohibition. Secondly, that should be an offense. Then the act or the contract should be void. The three matters should be specifically mentioned in that. The court cited Fernando versus Ramanathan, 16 NLR 337. In that case, the full bench decision given. The court decided that deed is not invalid on the ground of illegality. It may be illegal document. It doesn't mean that deed is invalid. There may be illegality, but it doesn't mean that it is void. It may be void or valid because it is contrary to what may be termed as the policy of the ordinance. The court stated that no argument were put forward that if it was allowed, the transaction which took place would defeat the provisions of any law. Similarly, no material was put forward to substantiate the fact that transaction is not one which is forbidden by law or fraudulent or involves or injury of another person or property of another person, and court regards it as immoral or public policy or opposed to public policy. There is no argument put forward in relation to the matters specified in section 4. Finally, the court held that the Finance Act empowered the commissioner to recover the tax. Now, even though the foreigner has purchased the property today, to avoid the payment of tax of 100%, whenever he transfers his property to his own name, he has to pay such amount of tax. The amount of tax. Therefore, there is no violation of any law. He did not violate any law. That's why Finance Act here empower the commissioner to recover tax whenever the property transferred to the foreigner. Second thing is, trust is not contrary to the sections 4 and 98 of the Trust Ordinance. Unlawful intention bilaterally entertained is no longer absolute bar to restitution. Finally, we will see two more slides here. A purchase by a judgment creditor of a property of his debtor at the sale in execution without sanction of the court, which court is lawful. that we will see this PowerPoint the presentation in another lectures. We will stop with this one. Thank you very much.